All right, I want to thank everyone for joining me today for this webinar. We're going to be talking about the COVID relief bill that was passed in December, and would like to just share with you some of the insights we've got from looking at the law and its impact on the FSA and DCAP plans and benefits. Before I get into all of that, though, let me just say that we appreciate the questions that were submitted when people registered. I'll be addressing those today at the end. If you do have additional questions, feel free to ask them in the Q&A function at the bottom of your screen. I'll also answer those at the end of the webinar. Of course, if we don't get to all your questions, we'll also be sending an FAQ to everyone after the webinar. And I'll also say if you have technical difficulties, please let us know by also using that Q&A chat feature. As a reminder, your audio and video has been turned off. All right, so the COVID relief bill was also known as the Consolidated Appropriations Act of 2021, signed into law on Sunday, December 27th, right at the end of the year. And what we're going to be talking about today is the impacts that law had on everyone's FSA and health FSA and dependent care assistant plans. Things to understand about what the legislators were trying to do. This law really follows regulatory attempts to mitigate the impact of COVID disruptions on the ability of plan participants to use their accounts. As we've all experienced, there's been a lot of layoffs, requirements to work from home, and limitations at the medical facilities. For example, elective procedures were not allowed. This all added up to really limiting people who had elected funds for dependent care and health FSAs from using them. And the regulators had tried to issue some regulations earlier in the 2020 to help mitigate some of this. With the ongoing COVID situation, though, it was realized that there really needed to be more done. And so in the last COVID relief package, we get the different rule allowances that we're going to talk about today. I'll also say that this was a very short section of a much larger bill. They didn't spend a lot of time thinking about maybe some of the language they've used. And so I think as we'll go through this, you'll see that there's going to be some areas where there's a little bit of gray, and we're hoping for some regulatory interpretation from the IRS to potentially help us better navigate these rules. But I'll highlight some of that as we get into it. A couple other things to know before I dive in. What we're talking about today are not mandatory requirements. Employers are not required to adopt these features. Think of them as outside limits of what a plan can do. And within these parameters, plans are able to kind of tailor the features to their situation. I'd also note that these changes are not permanent, and they are going to expire at some point. So keep that in mind as you consider whether you want to adopt them or not. Okay, we'll start with the carryover and grace period rules. Essentially, what the law allows is for a dependent care or health FSA to carry over all unused funds from the plan year ending in 2020 to the plan year ending in 2021. And also, again, carry over unused amounts from the plan year ending in 2021 to the plan year ending in 2022. With a grace period, it allows the grace period to be extended from 2.5 months to 12 months. And that would also apply for plan years ending in 2020 or 2021 for that extension to happen. And this would allow also all unused benefits to be used in that grace period. Just to keep in mind, you can't have both a carryover and grace period. The grace period rule is similar to the one that we've had in 2020, which was a regulatory exception for the 2020 year. And so they're just allowing this to continue on for a couple more plan years. Next, we'll move to the FSA Spend Down. This is going to allow health FSA participants who terminated during the 2020 or 2021 plan year to spend down their unused balances incurred through the end of the plan year in which that termination occurred. And that would include any grace periods. I'll highlight the fact this is unused balances. And I would just say that plans considering this FSA spend down should consider that potentially admin fees would be billed on those terminated individuals because they're still using their account. And also, I would also say that with terminate, that term, understand that terminate can mean in this context employees who are terminating, but also potentially employees who are no longer eligible for the plan but are still employed, and so they've essentially terminated from that plan participation. And so as you think about this rule and adopting it, whether you want to extend it to all participants who terminate, and also just keep in mind that this would also raise the risk that the FSA plan may not be in the positive because potentially you're going to have more funds going out than coming in because for our systems, we'd have to use the elected amount and not the unused balance amount. Okay, and we're moving on to the Decap Age Increase. So what this is doing is extending the maximum age of dependents who are eligible for funds to be used on their expenses from the age of 12 to 13. And this would be used for the 2020 plan year and for unused amounts in the 2020 plan year that can be carried over into the 2021 plan year. And let me just talk about what the 12 to 13 age limit really means. The normal rule is that a child or dependent would age out when they're on their 13th birthday, and after that, dependent care funds couldn't be used on their dependent care expenses. This is basically moving that up to their 14th birthday, so they'd be able to use it throughout the age of 13. I would also say that this is really kind of earmarked for the situation where that somebody has a child, only one, they're maybe not going to be able to use it, their unused funds from the last plan year because their child's aged out, and even if a plan adopted the grace period or carryover provision, it wouldn't do them much good because they have no other children to spend the money on. And so this is kind of meant to help them on that. But I would also just highlight the fact that it's the unused amounts from the 2020 plan year, that this is not allowing newly elected amounts on those dependents. So keep that in mind with this rule. It's a pretty narrow one in my mind. And now we're talking about election changes. So this rule would allow the DCAP and FSA elections to be changed for any reason in 2021 without a corresponding change in status event. This applies to DCAP and the health FSAs. You'll probably want to consider maybe some administrative conditions on this. And you can pick and choose. You don't have to do dependent care and health FSA. You could do one or the other. And so it's a pretty broad rule meant to maximize flexibility. In my mind, it really is much more beneficial to the health FSA than the dependent care. Dependent care had more flexibility built into the existing rules to allow changes for cost reasons. Health FSAs didn't have that, and so individuals in a dependent care probably won't see as much benefit from this because they could always change their election amount if their situation with their provider changed, and it led to some kind of cost change. I would also just highlight the fact that this would require all of these would require amendments to happen, and it's a pretty broad rule. Okay, so that is the end of the different rules. As I said, they were pretty short from a writing standpoint, but I wanted to touch on a couple things to think about. Plan amendments are required. You must amend your plan by, as the law kind of states, by not later than the last day of the first calendar year beginning after the end of the plan year in which the amendment is effective. That's a bit of a tongue twister, and what they're saying is, for example, if you have a calendar year 2021 plan, your amendment that's going to go into effect for this 2021 plan year would have to be done by December 31st, 2022. So it's essentially the year after your plan year. So you have a lot of time to get these amendments done. And of course, Further would be able to assist with that amendment process. Consider that changes to the FSA may cause the plan to pay more than is contributed. That's really in the context of the spend down provision and just the way that Further has to operationalize that. And also consider qualifying when an election change is allowed. You probably don't want to allow employees to make election changes at any point in the year and have an unlimited ability to do that. You certainly could if you wanted to administratively. I'm not sure that is the best route. Also keep in mind that the election changes have to be prospective. There aren't any refunds that are allowed. So if somebody wants to come along in the middle of the year and change their election amount down to zero, it doesn't mean that what they've contributed and not spent can be refunded to them. It just means that they have that amount that's been contributed left to spend for the rest of the year. And future contributions are zero at that point. And finally, I just want to make sure everybody's aware that if there is an extension to the grace period or the carryover from an FSA perspective that would impact HSA eligibility, you would, a participant who has a feature like this would need to have a limited purpose FSA. You'd have to make sure that your plan design includes that. I'd also point out that with the grace period, that's a little bit tricky because you have to have everybody on that limited purpose FSA. And so just keep that in mind as you consider these options if you're also allowing, if you have an HSA plan or potentially a member who has a spouse with another employer who's also going to get on an HSA. If they're covered by the FSA, they would have an impact to their eligibility as well. So a couple things to think about as you navigate this from an employee relations standpoint.